So welcome everybody. I'm pleased to be able to chair this session on hybrid stroke integrated mediation. My name's Naomi Luce and I'm the founder of Luce Legal, a specialist national family law practice. I'm an accredited hybrid child inclusive mediator, nice mouthful, a collaborative lawyer, parenting coordinator and family solicitor. And I'm pleased today to be joined by Karen Walker and Susan Kingston. Karen is the founder of the award-winning niche family law practice KGW Family Law, based in Woking, Surrey. In addition to her role as a family lawyer, Karen is a mediator, both hybrid and child inclusive, collaborative practitioner, arbitrator, neutral evaluator, trainer, and published author. She has developed a specialism in advising clients who find themselves subject to narcissistic abuse and hosts the highly successful podcast, How to Leave a Narcissist, the Practical Podcast. Susan is widely known for her expertise in all aspects of family work, in particular the resolution of complex financial issues for high net worth individuals. Susan's cases often have an international element, and she has considerable experience in dealing with prenuptial agreements and cohabitation issues. Often referred to as the Queen of Arbitration and Mediation, Susanna has a thriving mediation and arbitration practice and teaches both. She is credited with spearheading family law arbitration in England and Wales and worldwide. So welcome, Karen and Susan. I'll pass it over to you guys.
Thank you.
Thank you. And can we move to the next slide, please? So this morning, we want to talk to you about the benefits of mediation and particularly the hybrid integrated mediation model. But I want to start by looking at what the benefits of mediation are for separating couples. I think that with all the different forms of NCDR, it becomes quite overwhelming for solicitors who don't necessarily understand all of the different options. So just imagine how complicated that is from the point of view of the client. But in essence, what a client wants to do is either be helped to reach their own solution, or if that absolutely proves impossible, they want some means of adjudication, for which we would both suggest arbitration is the best route. But focusing on mediation, which is what we're here to talk about this morning, what are the benefits? Well, first of all, it's a discursive process. So if you have a family, if you've got children, really whatever their age they are, because divorce is as difficult for adult children as it is for small ones, maintaining some form of communication is absolutely vital. And mediation provides not only the forum to do that at the outset, but also the opportunity to revert back to that process if issues crop up along the way, such as perhaps variation of maintenance, perhaps ongoing issues in relation to children, where are they going to go to secondary school, other issues that might arise. And you're able to build up that rapport with the mediator, who's there to assist at every stage moving forwards. There's no need to be positional. I think that the private FDR has understandably become very much the go-to form of out-of-court dispute resolution, particularly for practitioners who are not trained themselves in other options of NCDR, because it follows the standard court process and it's what we all understand. But I would say the problem with the private FDR is the need to be positional at the outset. So inevitably, if you're going to reach a settlement, compromise is an inevitability and often very unpalatable, because the couple will come to that session with a firm belief that their position is right, or as close to right as they can hope it might be. And the only way really from there is down. So in mediation, you have an opportunity to organically develop an outcome. So rather than looking at a set position, you're going to discuss with the couple what's really important to them. What do they want to go to hell in a handcart over, and what might they move away from? And take those strands and develop them. It's a very safe environment because everything is without prejudice. So you can think of options and throw around ideas and nothing is going to come back to haunt you. And most importantly, the mediator is a neutral facilitator. So they're working equally with each of the couple and they're not seen as being partisan in any way. So can I have the next slide and pass to Suzanne?
Thanks very much, Karen. So basically, here we're looking at the fusion of the civil commercial model with the family model. So we all know the family model. That's how we've been brought up. That would be typically an hour and a half. And when we were taught by Henry Brown on this hybrid model, he said there was no real magic to that. It was just felt that an hour and a half felt right. And perhaps for some people, that's the right length of time, but there's no magic to that timing. We know that typically the lawyers don't attend in a classic mediation. And certainly the mediator doesn't hold confidences. So if we're looking at the hybrid model, we're looking at the fusion of the civil commercial model with the family model. So what might be different? Well, one thing might be that the time may be much longer. So you might have one block of time that's a half day or a day. I've had a hybrid model mediation that was 4 days. So depending on the complexity, what people want to resolve, and the conflict, how high conflict it is, you might have quite a long block of time for the mediation. Typically, you would have joint meetings with oral presentations followed by separate confidential meetings. So typically what we'll be saying as we're seeing as we go through the process is that we'd have the usual intake, then we'd have a joint meeting with each of the couple or the lawyers, if the lawyers are in attendance, speaking about what they want the mediator to consider, and then followed by separate confidential meetings where the mediator shuttles between the two, making it clear that these meetings are confidential, but also making it very clear what they're going to hold as confidences and what they're not going to, and discussing in detail why confidences should be held or should not be held. There's also the step of information gathering. So the parties normally provide case summaries and copy documents pre-mediation. That's, I suppose, a bit different. And the lawyers are most likely to participate directly. We're going to discuss in detail as we go through this how the lawyers, what role they take in a hybrid model. But quite often the lawyers are in the meeting. So it's lawyer assisted mediation, lawyer attended mediation. And the agreement to mediate is approved for signature before the mediation starts. And just a reminder there that if the lawyers are present in the mediation, then they should also be signing the agreement to mediate so that they will be held to the same terms and the same ideas of things like confidentiality as the parties. So if we can go on to the next slide.
So how does this process actually work from the outset? The initial step is to have individual intake meetings with each of the couples. So along the lines of the usual MIAM mediation information and assessment meeting. The purpose of that is to talk through with each of the couple whether this is a process which would suit them and why. I think it's particularly helpful for those couples who might otherwise litigate, who might either be a very high conflict situation or a very complex situation, where at the initial stage they may feel, I would say incorrectly, that court is the right place for them. And that individual intake meeting provides the forum within which to discuss what the detail is of the case, what the expectations of each of the couple are, what they want to achieve from the process, what their concerns are, why they think that perhaps a discursive process like mediation might be difficult, and what steps could be taken to alleviate those difficulties right at the outset. So they're very, very important meetings. They're normally about an hour in duration, and important, I think, not to undervalue the benefit of that initial intake meeting, and very important for the mediator to ask quite searching questions so that they can really establish how they're going to create this bespoke service that is going to hopefully achieve a resolution for this particular couple. It's an opportunity to discuss whether they want their lawyers to be present. Now, incorrectly, there's an assumption that hybrid mediation means that lawyers attend. That's not right. The only difference between the hybrid model and what I would call the classic model is the mediator's ability to hold confidences, which we're going to talk about more. But particularly if it's a high conflict case or a very complex case, having that legal advice available on the day of the mediation can be invaluable. And we're going to talk a little bit more about that. It makes the client feel safe. It makes them feel that they can make decisions on the back of advice rather than collecting a whole set of questions at the mediation session, which they then take back to their lawyers, which has the inevitable outcome of elongating the process. Also, particularly in high conflict or high complex cases, it's much more likely that certainly initially the couple are going to want to be in separate breakout rooms, either physically or remotely. And so while the mediator is with the other spouse or partner, that person can talk to their lawyer, and the mediator will give them homework, which we will discuss again in greater detail later, to make very, very beneficial use of that time. So you're going to be talking in the initial sessions about whether separate or joint meetings might be better, looking at the benefits of each. Perhaps, as I say, if the couple don't feel comfortable being in the presence of one another, starting in separate meetings might be the right way. You might think about whether you are going to have everybody on screen or in person at the outset together, just to show that we're all human beings working to a common objective, and then move to separation. But we can run it in whichever way works best for the couple, and you're going to gain that information from the parties at that individual stage. So if we could move to the next slide.
So on the next slide, we're talking about what information is required. So much of this is what would be required in a classic mediation. But if we look at it in detail, first of all, the background information. So all of the information you would expect on your preliminary information form that you would have sent to the couple prior to your intake session. And that's essentially what you will be going through in your intake session, as well as all of the other points that Karen raised. From that, you'll be able to glean if there are any issues that are going to arise, any particular safeguarding issues or domestic abuse or anything like that. You'll also want to know the current position of each party, so what it is they would like to achieve. And I think it is great that mediation is a without prejudice process, because what that enables people to do is to really test out ideas. And I've sometimes been engaged as a mediator just for that purpose. So in a without prejudice environment, to really test out potential ideas and solutions with the lawyers and the clients present. The question posed there is, should position statements be avoided? And I think position statements in a traditional sense of how you might use them in court should be avoided. But if the lawyers, in particular, if there are lawyers present, they want to put forward their client's position, then they can do that, but be very careful about the language that they're using and how they're framing their client's situation. So thinking really, really carefully about that. And that's something that the mediator should be able to discuss with the lawyers. So if the mediator feels that the lawyers are being too aggressive, too positional, then, or perhaps treating it like a court process, then it should be open to the mediator to say that's not how this is going to work. And so we need to take it down a notch or two. Quite often, the mediator is presented with a joint asset schedule, and there you'll see notes on the right-hand side of things that need to be discussed or where there may be differences of opinion. So that's really guiding the mediator to the questions that need to be raised. And often, if you're dealing in a big case, you'll be given a mediation bundle that's agreed between the lawyers. So they have considered carefully what the bundle should contain, and that's sent to the mediator in advance of the mediation. So the mediator has a really good sense of what the case is about. So there's quite a lot of preloading and work that's undertaken, even necessarily, before everyone has met in the forum. So quite often you might have some of this stuff given to you in advance of the mediation itself. So if we look at the next slide.
Thanks, Suzanne. I've just seen in the Q&A bar a couple of questions, which I think this would be quite a good juncture to answer. The first was, is the lawyer, or are the lawyers, or the mediator in charge of the mediation? The mediation is the couple's process. So it's their mediation, and it is managed by the mediator. The lawyers are there to provide support, which I'm going to talk about on this slide. So I think very important to remember that. There was another question about costing for this. Obviously, the mediator will charge their rate. As a mediator, I charge almost exactly my hourly rate as a solicitor, and lawyers will charge whatever is agreed with their clients. But all of that will be set out in advance so that the clients understand what they're paying to whom. So the benefits of lawyer support. First of all, the initial reaction from the client is it seems quite expensive. They're paying all of a lawyer and half of a mediator. And how's that going to work? Sort of sharp intake of breath. But actually, having your lawyers present can be cheaper for a variety of reasons. One, you're going to concertina the process. So there's no requirement to go to mediation, gather up your list of questions on which you need advice, move to meet with your lawyer some 2-3 weeks later, then reconvene with the mediator 2-3 weeks after that. So it definitely shortens the process. I think with lawyers there, the mediation becomes much more focused. Clients are taking advice in real time. And so probably you would need fewer mediation sessions. Also, from my perspective, if lawyers are present, I wouldn't draft a memorandum of understanding at the conclusion of the mediation, because my expectation is that the lawyers have their own notes, and therefore I'm not charging the couple for that service. So they're probably saving the cost of an hour of my time there, which they can put towards the cost of their lawyers. If you're going to have lawyers in attendance, first of all, you need to have a professionals meeting in advance. So that would take place in between the intake meetings with the couple and before the first joint session. It's quite important for the mediator to clearly explain to the lawyers what their role is. It is support. This isn't a roundtable meeting. And it's very important that everybody understands what they're going to be doing within the process to take that forwards. Can one person be represented and the other not? I think that's something that you would want to talk about in the initial intake sessions. Of course, you can run the mediation in a way that works for the mediator and the couple. Sometimes clients might want to bring along not their lawyer, but a family member there to give support, and provided the other person is in agreement with that, and the attending third party would sign the mediation agreement in terms of the confidentiality, then if it helps that person feel more comfortable and is more likely to achieve settlement, it's something that you would want to think about. But it does slightly skew the playing field if one person is represented and the other isn't. So very important that the mediator carefully manages that, and that it is discussed with both of the couple, that they feel comfortable moving forwards in that way. Of course, if you have lawyers present and you're able to alight on a set of proposals at the end of the mediation with which both of the couple are content to move forwards, it's open to the lawyers, if they are in agreement with each of their clients, to lift the veil of privilege from the mediation, create an open meeting, and achieve a binding agreement there and then. And of course, that can be very, very beneficial to the couple, particularly if you're in quite a difficult, quite controlling, coercive relationship, perhaps with a spouse or partner who might be moving goalposts all the time and apparently agreeing to something 1 minute and half an hour later saying they didn't have that conversation. You're going to want to nail them to an agreement rather than allow them to take control of the process and let the meetings just run and run indefinitely. So maybe very, very beneficial in those circumstances to have the opportunity for the lawyers to create heads of terms, which would be signed at the end of the mediation. And of course, the mediator would talk through with the couple exactly what the basis of those terms was. If you want to be really swanky. As a lawyer, you might even come armed with a draft consent order and have the opportunity to draft that document with the other side also present and the parties there ready to sign. And even if you could, if the relevant information is in the mediation bundle, you might even be looking at the possibility of completing your D81 at the same time, so that at the very end of the process, you have a pack which is all good to go and to be submitted to the court. But I do want to underline, this isn't a roundtable meeting. The role of the lawyer is a supporting role and a very, very vital role, hugely valuable role. But it's not to take over control of the mediation itself. And could we have the next slide, please?
So just emphasising there the role of the parties' lawyers and what Karen has been saying about the lawyers supporting the process. And it is the mediator's process. So it's up to the mediator to keep control of the mediation and make sure that they are taking it further forward at each stage. I find it really helpful, therefore, to do an agenda prior to the mediation and send that to the parties and to the lawyers in advance, just saying, this is my proposed agenda. Please let me know if you have any additions or amendments you would like to make. Because then you can really work to your agenda, and that's helpful. And if someone is trying to sort of hijack the mediation, you can bring it back to your agenda. So I find that helpful. So making it clear to the lawyers what their role is, perhaps if they haven't been in a mediation before, explaining that very explicitly at the outset of the mediation and as you go through the process. So you would probably ask the parties' lawyers to provide information in the Form E. And I always say to people that it's really important that the information is checked by their lawyers, because obviously a mediation Form E is an open document and can be used if mediation fails and the parties end up in court. So it's really important that what's set out in a Form E is accurate. Obviously, the lawyers are going to be liaising with the mediator as the process develops. And the lawyers may attend some sessions, but not all of the sessions. So it was incumbent on the mediator to say whether or not they envisage at the next session the lawyers are going to be present or perhaps not. And sometimes it's just good enough to have the lawyers on hand. You can have them by phone. You can say, if you can be in your office, but if we need you, can we please phone you? That's really, really helpful. Karen's already mentioned that you can ask the lawyers to draft the settlement documents, therefore making the process much cheaper than the mediator's summaries. So that is also possible. So again, thinking outside the box, the sort of things that the lawyers can do in this scenario. So if we can move to the next slide, please.
So looking at the professionals meeting, I see that there's a question in the box asking who is more likely to suggest the lawyer being present at the mediation, the mediator or the lawyer. It's something that the mediator is going to discuss with the couple in those initial intake meetings, and it's going to be ideally for the mediator to consider with the parties what the benefits of having their lawyers present might be. You might have a lawyer who recommends the hybrid mediation model to you as a mediator on the basis that they want to come along with their client. But if there's an ultimate decision to be taken, it's going to be between the mediator and the couple themselves. That said, I personally think that having lawyers in the process works extremely well. The professionals meeting is with both lawyers present, not the couple. The mediator and the two lawyers deals with another question in the box. And the question about does this work with the narcissistic party, I will deal with at the end as suggested. So looking at what the purpose of the professionals meeting is, you're scoping out the mediation. So you're discussing with the lawyers how this mediation is best going to work. You're also explaining to the lawyers how the process works and what their role will be. You'll be asking them whether they perceive any problems, any difficulties, any concerns that they have. you often ascertain at the professionals meeting that perhaps there's a hiccup over disclosure or something that hasn't been provided. And you can discuss that jointly with the lawyers as to how important it is that we know what there is before we start discussing how we divide it. And so also looking at the opportunity of setting out what information each of the couple is going to provide into the mediation. It's going to lie with the lawyers to put together a bundle of documents which they want the mediator to read, and they would want to decide which are going to be the most important documents. So not just glibly putting everything that's been provided all into one huge pack and wasting the mediator's time in having to read that and the party's money, but actually discussing quite clearly, what might be required in terms of disclosure, but then more specifically, what documentation is going to be provided to the mediator to read in advance of the first joint session. At the professionals meeting, you're also going to discuss the timetable of the mediation. Of course, as mediators, we need to be nimble, and so that timetable may be adjusted as we go through the process, but giving the couple an idea of timescale, following on from the professionals meeting before the first joint session, so they've got a framework in place. Again, goes back to that point of certainty and establishing a process which everybody understands and everybody then is comfortable to move forwards with. If we could move to the next slide.
So we're looking now about how we're adapting the civil commercial model into this new hybrid scenario, and the standard family model remains the core basis. So what you're used to can be a hybrid mediation, and it can be used without adaptation if you think that that's appropriate. And I think what both Karen and I do and would urge you to do is, if you are hybrid mediator trained, then to use the agreement to mediate that enables you to use either the hybrid model or the classic model when you're setting out a mediation, because you may not know at the outset whether or not it's going to be hybrid. And just reminding everyone, because I think it's so crucial, that the only difference between classic and hybrid is the ability of the mediator to hold confidences. And that's what we're going to be really looking at next in detail. So some of the things that you might do, and we've already discussed this, in order to have a hybrid type of mediation, the parties' lawyers are likely to be more directly involved, but that doesn't mean it's hybrid. It just means it's lawyer assisted or lawyer attended. The mediator can have separate confidential meetings with each party and with his or her lawyer. And that's the mark of it being hybrid. That's the differentiator. The point that makes it hybrid is the ability for the mediator to have separate confidential meetings. When the mediator's doing that, they have to be really careful, make a very clear note of what is going to be confidential and what is not, repeat it back so that everybody understands what they want to remain confidential, and probably say to the lawyer and the parties, although you want me to keep this confidential for the time being, I won't be able to keep it confidential forever. We are going to have to explain this later on. So can we have a time frame around how long this piece of information is going to be confidential? We know that the meeting length can vary, so it might be a much longer meeting. So you might have a situation in a hybrid mediation where you're going to the mediator for a whole day. The mediator may directly involve other professionals in the process, so an accountant or a trustee, and that is often undertaken in the hybrid model, but also in the classic model. I've had classic mediations where an accountant has been present or an IFA. Again, just to reiterate, there is a possibility of having private communication between sessions, although both Karen and I think, take the view that we would prefer that not to happen. If there are going to be private communications in the separate confidential meetings, then that should take place in the mediation itself. So just reminder, the differentiator for hybrid mediation is the ability of the mediator to hold confidences. So if we can look at the next slide.
Thanks, Suzanne. I'm just going to answer one question quickly that's in the chat box, which is, can any mediator offer hybrid mediation? The answer to that is no. Hybrid mediators are very specifically trained to deal with the method of holding confidences. Suzanne and I run a training course through Resolution for that. But it is a very specific form of mediation and should only be undertaken by those who have had the training. In terms of evidential status and how that sits with the confidential meetings, so we have to reconcile what information can be held confidentially and what can't. Obvious example, if a client says, I won the lottery at the weekend but don't tell anyone, of course that has to be disclosed. I think perhaps more importantly, things like my partner's pregnant but don't tell my wife, or I'm pregnant but don't tell my husband, is obviously that's something that's a factual issue, and anything factual or financial cannot be held as a confidence by the mediator. That would be completely inappropriate. But the benefit of holding confidences is quite wide. First of all, and this will tie in slightly with the answer of can you use this model if you have one party who's narcissistic. The mediator during the intake sessions can find out information confidentially about each of the couple's perspective of the marriage, the relationship, what's been going on. Now, very often the mediator may well be told that both of the couple are narcissistic. That's not uncommon. But the mediator can use their skill set. They're not diagnostic. They're not there to make any decisions in terms of personality. But they can use that confidential information to help them manage the mediation process. Also, I think one of the main benefits is perhaps one of the couple will say, look, my bottom line is I'm prepared to do X with the house, but provided other things happen as well. But I don't want you to tell the other person that. I want to find out what their direction of travel is first. So the mediator can hold that information in their head, firmly in the knowledge that there's going to be some movement from the other side of that nature, not revealing it, but using it to just guide and nudge the mediation discussion in a direction which the mediator is fairly confident is going to go the right way. Obviously, if anything that involves significant harm to children or others is raised, we will have our professional safeguarding obligations in relation to that. And I just make a quick point there about safeguarding, that we don't just deal with safeguarding at the intake meeting. Safeguarding is something that you are reinforcing every time you meet with the couple, particularly if they're high conflict, just to check in that nothing's changed since you last made a safeguarding assessment. You'll find the hybrid agreement to mediate on the Resolution website. The only difference between the classic agreement and the hybrid agreement is paragraph 9, and that provides the hybrid mediator with the ability to hold confidences. So some preliminary questions. What kinds of issues are best dealt with separately? I think issues of this is a controlling relationship, actually I'm prepared to take less than I might be entitled to because I want to get out of this quickly, and that has a huge value to me. Those are confidential issues which you might discuss. Similarly, in terms of, as I've said earlier, outcome, if somebody feels, look, I want to do a deal, I'm prepared to go to what they want on this point, but there's got to be some compromise for me on other issues, don't tell them that I'm prepared to do that. Can be a very, very useful tool and assisted by lawyers within that. I think just to touch on there, a question in the chat bar about if you've got a lawyer who's hell-bent on achieving the best possible outcome for their client. Well, of course, that's what every lawyer is there to do, but the best possible outcome very often is a compromise. That's the best outcome for the family as a whole. And so I think, important at the professionals meeting to have that clarity with the professionals that if everybody stays at the outer edge of the bracket, nobody's going to get anywhere. That's why people litigate and judges make a decision. And so I think it's important to make that clear with the lawyers. Moving to a separate meeting or not is really at the discretion of the mediator. As Suzanne has said, it's the mediator's process. They are in control of this. Ideally, they're going to be trying to get the couple to come together and to be in the same room at the same time, because of course that means they hear everything at the same time, and that's very beneficial. But some people just can't cope with that. They don't feel even supported by their lawyer that they can sit in the same place. And so it's about the mediator identifying the balance, recognizing when somebody wants to hold something confidentially with the mediator, wants to have a confidential discussion, feels more comfortable being separate, and using their skill set to manage the process to create the best possible environment with that balance of confidentiality and separate meetings to create a safe space within which settlement can be achieved. If we could move to the next slide, please.
So we're now going to talk about the practical considerations when dealing with this sort of mediation. Some of them are the same as classic, as you would expect, venue and room arrangements. So thinking very carefully about the venue for the mediation and the room arrangements. We would expect, because there's likely to be some shuttling by the mediator, that each party would have their own separate room as well as the joint room with the mediator. So making sure that you have 3 good sized rooms, particularly if lawyers are present, to be in the mediation, and using the initial sessions to establish underlying issues and create boundaries. So perhaps as the mediator, you may be feeling in this sort of situation that the lawyers might take over the process. So it would be incumbent on you as the mediator to set out some ground rules about how you expect people to behave within the mediation. And it's up to you as the mediator to determine when the lawyers are going to be present and how long for. If they're going to be present for the whole session or part of the session, are they going to just be available remotely so that they can come in and help if necessary? So Karen has already mentioned how the mediator has to be quite nimble when dealing with this type of mediation. I would entirely agree. Now, one of the issues might be that the parties might find it difficult being in separate rooms. They may not like the idea that the mediator is talking to their ex-husband or wife, and they may be very concerned about that. So it's up to the mediator to make sure that that's all set out carefully, that they are spending approximately equal time with each of the parties. And if for some reason they need to spend more time with one of the parties, then to make that very clear, to say to the other one, I'm really sorry, but I need to spend a bit more time today with your wife. I will make sure that we cover all of the points that you want to raise with me, but she's very upset at the moment. And so I just wanted to say that to you. But if not, if you can try and keep to broadly equal time with each of the parties, I think that would be very helpful. As I say, it's up to the mediator when the lawyers are present and when they're not. This type of mediation is often used in high conflict cases or complex cases. So there probably will be a lot more preparation by the mediator to make sure that everything stays on an even keel. So the mediator will be thinking throughout, what am I going to be discussing at the next session, and what strategies am I going to deploy in this session? How much do I want to hear from the parties? How much do I want to hear from the parties' lawyers? And really choreographing the mediation in advance. And we often get asked, what does the other party do while the mediator is with their spouse or partner? With that, we want to make sure that we give them some homework to do, a job to do. So possibly looking at some property particulars or considering their spouse's budget, so that they're doing something rather than just sitting there and worrying about the sorts of conversations that you might be having with the other party. Really important to make sure that everybody's got something to do whilst you're shuttling as a mediator. So if we look at the next slide.
Thanks, Suzanne. I just want to pick up very quickly on a question in the chat bar about what if one side, lawyer and party, want to derail the timetable, and it goes hand in glove with another question, which is, my view is the mediator would have a further professionals meeting to talk to the two lawyers about the need to keep to timetable, and I think it underlines Suzanne's point that this is the mediator's process and the mediator is staying in charge of it. So just going to my slide. So who to see first? Have a mechanism as to who you're going to meet with first. I use first name alphabetically just because it's fairly neutral. I think do whatever you want, but have that mechanism to do it. I had a case where I sent something to mediation. My client got very upset that the mediator was always seeing her husband first. I was quite surprised. It was a mediator I knew well, and I knew they'd be managing the process properly. It was simply because he always arrived very early and the mediator just wanted to get on with things as they were staying separate. But I think as a mediator, you do just need to be aware of that. And using waiting time effectively, Suzanne's already talked about giving homework to the person who's sitting otherwise twiddling their thumbs. Important to maintain a time balance. Now, it's not always possible to spend equal time with each of the couple. Very often you will have one who is slower at dealing with things. Perhaps one is very used to handling business meetings, charges through everything like a fast train, and the other needs to turn everything over 6 times and think about it carefully. You will want to explain to the person with whom you might spend less time that actually it is to their benefit that you do so. And it doesn't mean that therefore they're being shortchanged in the cost of the mediation, because your role as mediator is to treat them as a couple and to give the best timing to each of them that's going to facilitate that discussion. But if you do find that you're going to be unduly lengthy in terms of time with one of the couple, important to touch base with the other. Don't say to one, right, I'm going to go and speak to your wife now, I'll be about 20 minutes, and 50 minutes later you haven't shown up. Always go back and touch base so that you are providing information, balance, you're being informative all the way through, which makes the couple feel that you are in control of the process. So it's about keeping them involved and informed at every step of the way. And also encouraging disclosure if that becomes an issue. It's something that you want to make very clear. Again, I saw in the chat bar, do the mediators do Form E? Yes, you can. In a high complex case, I wouldn't. I would give that as a job to the lawyers. It's a really important document. I think it needs to be prepared by somebody who's on the client's side, looking at what they need to set out. And of course, don't forget it's the lawyer's insurance that's on the line in terms of the outcome. So, but it's up to the mediator. It's your process, and you would work it in the way that works best for that particular couple. And I'll go to the next slide and hand back to Suzanne.
I'm just noticing, Karen, we're whizzing through our slides. And so, Naomi, just to say, I know there's lots of questions in the chat, and perhaps we'll mop them up at the end when we've finished our slides, because there's quite a few and there's some interesting questions there. So I will just go on to deal with the summary here. So in summary, I think both Karen and I would agree that hybrid mediation provides a very safe environment for people to mediate, particularly where litigation would be something that they would be considering as an alternative, or arbitration, particularly where you've got high conflict cases or complex cases where you think it may be useful to have other people involved, not just the parties. So the parties' lawyers, as we've indicated, you might also have accountants, IFAs in the room to assist the mediator. It's really helpful to have the lawyers to give advice in the room, or at least with their own client, in real time, because I'm sure that when we're doing classic mediation, when people go away and they speak to their lawyers, you lose momentum. So having the ability to do that right there is really, really important. It's very important for the mediator to be very clear about what is a confidence and what's not, and how that confidence is going to be used and when. So perhaps challenging the parties as to why they want to hold confidences and when the confidence can be released. There's no requirement to be positional. In fact, we would say probably don't be too positional. Still allow the evolution of ideas and concepts to come into the mediation so as to ensure that everything is resolved sensibly. Reminding us that at all times, the mediation is the neutral facilitator. So it's the mediator's process. The mediator is the one who's done the agenda, who's keeping to the agenda and moving things on, hopefully to reach an outcome. And I saw in the chat there was a question about how often this is used. And I'm doing so much hybrid mediation at the moment, as I know Karen is. Really, so many people coming saying this is their preferred option. We have trained a lot of people, and so you will be able to see people who are hybrid mediation trained and be able to choose them as your potential mediator in your geographic region. Although obviously, if you're doing it remotely these days, it doesn't necessarily have to be in your geographic region. But I think it really provides a better platform for ongoing child parenting and maintaining civil relationships. And that's something that all of us in the NCDR world are out to do. We're trying our best to ensure that the mere split of a partnership doesn't cause terrible trauma and difficulty for each of the parents and for the children. We're trying our best to ensure that they're able to maintain decent relationships so that at the end of a mediation, for example, the parents can co-grandparent in due course, they can go to their children's weddings, and really try and have that sort of better platform for everybody involved in hybrid mediation. So I hope in doing this, we've managed to explain as much as we can about hybrid mediation. I know that both Karen and I are happy to answer any questions, Naomi, if you want to raise them.
Yes, thank you, Suzanne and Karen. That's a brilliant overview of hybrid mediation and what it involves. Karen has actually done a brilliant job of kind of mopping up a lot of the questions as we've been going along. But there was the one from someone about have you seen hybrid mediation work successfully when one party is a narcissist? And if so, what is required for this to be successful?
So I did a webinar, I think last year, with Kelly Lawler about what can you mediate with a narcissist. I don't think you can mediate in the classic format with a narcissist. They will use that process to take centre stage, to spin a triangle, cause all kinds of problems. But I do think that hybrid works, and I have had quite a few successful mediations, both where I've been the lawyer and the mediator, where there's been somebody who one might assume has narcissistic personality issues. And the reason for that is that the ability to hold confidences and have separate meetings enables the mediator to discuss with each of the couple what their concerns are about the relationship. And as I say, we can't be diagnostic, we're not qualified to be so, but we can form a view about what actually might be going on here based on what we're told. If one of the couple is narcissistic, it's going to be very important that they feel special, and that they feel that not that the mediator is aligned with them, but they are taking account of what they want, what they need, putting them very much centre stage. And the mediator can explain confidentially to the other partner or spouse, who may be the one who said, look, I think he or she is narcissistic. Look, if we're going to achieve a settlement, that's what I have to do as a mediator. That's part of my skill set, because they're going to need to feel special in this process if they're going to agree to anything. The other person may say, look, I know I could get X out of the house, but I'm prepared to take a bit less, weighing up legal fees just to get out of this. And so the mediator can also take account of that, talk to that person's lawyer confidentially about how important it is for them to achieve it. And I think we do a specific element of training on personality disorder, not just narcissism, within the hybrid mediation training. And so mediators who are so trained have the ability to pick up on the nuances that they're looking for, and to guide to an outcome. So I think if you're going to achieve successful resolution in any process that's out of court, that's not adjudicative, hybrid mediation is it.
And Karen, I know there's quite a lot of chats about when the next training is, and it's the 27th and 28th of April, and that's in person via resolution. So we do host it in person via resolution. If anybody's interested, 27th and 28th of April.
Thanks for that, Suzanne. And then another question that we've had come through is, can hybrid mediation be introduced at any time during mediation, i.e. following first joint session, or do participants need to decide after their MIAM?
They can, at any stage, you can use it, which is why I think we're suggesting using the hybrid, for the mediator to use the hybrid mediation agreement, which has an additional paragraph about holding confidences. So that it's on the resolution website, and we would urge mediators who are hybrid trained to use that so that they can do a hybrid model if they needed to.
I think perhaps the question also relates to if you started with a non-hybrid mediator, could you change? I think personally, I think you would have to change mediator if you were going to use the hybrid model. I agree with Suzanne. I always use the hybrid agreement now, because you might as well have the opportunity to use confidences or not. Not everybody needs to use the hybrid model, and I think it's something that all mediators should discuss in those intake sessions, so that actually, if that's the model that would better suit the couple and they're not able to provide it, I think pass them to somebody who can, or do the training is the other obvious way forwards.
And in fact, that's happened.
Sorry, Suzanne.
I was going to say, in fact, that's happened to me a couple of times where people have started a mediation and then realised that it would be perfect for hybrid, and they are not hybrid trained. And so they've asked me to take over, or in fact co-mediate, so that they can see what I'm doing on a hybrid basis.
And that's the beauty of these types of sessions, isn't it? To get the information out about the hybrid, so that it does then form part of your MIAM discussion, your initial option discussions with clients. So it's not just the mediators that are telling the clients about this option. It's also coming from the solicitors as well, so that everyone is aware that this is a brilliant way of being able to expand the NCDR offering, and kind of tailor mediation. That's the way that I see hybrid anyway, is tailoring mediation to actually meet the needs of the participants that you've got in front of you.
Yeah, absolutely. And I think it shows how our community works so well together, where one mediator would contact another mediator and ask them to help because they're not trained. I think that's one of the great things about the NCDR community.
Yeah, that's what I was going to say, Suzanne. And I think I would add how important it is for the first port of call, which is often the lawyer, to really understand these options, because it's not about bombarding your client with all different labels of various things, but it's looking about what they need and what can you, as a value adding service, direct them towards. And of course, if you are the lawyer, probably, especially if it's high conflict, you're going to have a vital, pivotal role in this process. So you're not losing the client. You're guiding them through something which is going to be beneficial for them.
Well, that brings me on to kind of another question. So what attitude have you found from the solicitors about this process? Are they fully kind of ready to engage, or?
I found them to really want to engage, because I think in the past, when people have gone into classic mediation, it's been a bit of a dark art. Their parties, the couple is sent off, and the lawyers don't really know what's happening. And then they appear again, perhaps with an agreement. Although I have to say, after every mediation session, I send a without prejudice email, subject to mediation privilege, making it clear what we've discussed to the clients, and say, please share this with their lawyers, because I want the lawyers to stay on board. But in the past, I think lawyers have been really nervous about the sort of things that are happening in mediation. Whereas if you have the opportunity to be there, participate, you can really see how the mediator's working. And I think it's one of the many ways in which mediation has become more and more popular, because lawyers are really grateful to the work that mediators do.
I think also lawyers that have done this once want to do it again and again. I found that there's lots of repeat work from people who've engaged in the process. I'm sure it's been the same for Suzanne. I've had a couple of lawyers attend with a degree of reluctance and trepidation, and that's been often selling it to their client, and the client said, no, I want to do this, and Karen says you should come along with me, and that's what I want you to do. And they're a bit like, why am I here, and how's it going to work? But at the professionals meeting, you can allay all of those fears, and I think once you've dipped your toe in the water, you really see what a great way it is to work. And you can bring in other professionals. I think there was a question about bringing in an IFA. You can bring in whoever you need, and you might involve counsel. I think that's becoming also more and more prevalent, that counsel are attending with the solicitor, particularly in the very complex cases where, why wouldn't you bring that advice to the mediation that you would otherwise take to court? It's not just about advocacy, it's about high level advice and steering.
Aaron, can I just make a point there that if other people are coming in, obviously the mediator needs to know, because it's all about balance. So the mediator would need to know if you wanted to bring your IFA or your counsel, so that the whole process would work. The mediator would check in with the other side and see what they thought about that. So just always a good sort of relationship and good contact between the clients and the lawyers and the mediator to keep everything on board.
And everyone would have to sign up to the mediation agreement as well.
Yeah.
So.
And there's quite a lot of talk in the chat about fees and the expenses of all of this. How do you kind of sell that to your client?
I don't think it's a question of selling, because I actually think it's a bit like arbitration. People always used to talk about how expensive arbitration was, but actually you're getting an adjudication very quickly if you want it. And so you don't have all the satellite correspondence that would go in a normal case. And similarly, when the lawyers are actually present and you're dealing with things in real time, you're able to deal with things very cost effectively and quickly with the lawyers there. And the lawyers may take over the role of doing some of the drafting, which they're used to, etc. So I really think that actually it is a cost effective way of dealing with things.
I mean, I think as a sort of finger in the wind, you probably wouldn't incur much more cost than you would up to somewhere between first appointment and FDR. It wouldn't be the same level of cost as taking you past an F by any stretch of the imagination. And I think that my fees as a mediator tend to be less in a hybrid because I don't have so many sessions. Yes, you've got the add-on of the lawyers, but you're going to take advice from them anyway. So there's no extra cost. What you're doing is shortening the process. So probably overall, it's more cost efficient.
And I suppose there are people around as well that do the fixed fees and things like that. So you could have a mediator that would offer a fixed fee for half a day, full day, that type of thing. So, at least then you've got the certainty in terms of costs as well.
Yeah, absolutely. Exactly.
So, okay, one kind of last quick question is, in the joint sessions, how much do the solicitors take part in the conversation, or do they mainly observe?
I think it depends on the case. That's very fact specific. So in a very complicated case, the solicitors might take more of a role, whereas in a less complicated, less. And in fact, you may then say to the solicitors, well, actually, or counsel, is it necessary for you to be here? Because I think most mediators are very cost aware and cost sensitive, and they're doing the job to make sure that the costs stay on, at a sensible level. So I've certainly intervened and said I don't think it's necessary for lawyers to be present on this occasion.
And that's the mediator's call. So just because lawyers are going to attend doesn't mean they come to every session. There may be sessions which don't require their presence at all. And actually, I think lawyers tend to be present less frequently when you're dealing with child arrangements, although it can be hugely beneficial. I did a complicated mediation where Suzanne was the mediator on child arrangements, and it was very helpful to have both lawyers there. So
well, I'm just conscious of time.
Yeah.
But it's been a really, really informative talk. Thank you so much, Suzanne and Karen. I absolutely love hybrid. To me, it's the main way to work as a mediator. And I would definitely encourage anybody to go and do the course.